Hello, my name is Brandon Davies. I'm a criminal defense lawyer based out of Overland Park, Kansas. In this video, I'm talking a little bit about administrative hearings in the DUI context. Now, where this comes up is when a person gets charged with a DUI and they either refuse to take a breath test or they blow over the legal limit and their license is taken and they get a DC-27, basically a notice of license suspension. Then an administrative case is kicked off on trying to take the person's driver's license away. Essentially, when you get a DUI, you have two cases, the criminal case, and then you have the administrative case. The criminal case is well known, the administrative case is less well known. The burdens of proof are one of the main differences on the criminal defense case versus the administrative case. On the criminal case, you enjoy the burden being in your favor, in which the state or the city has to prove beyond a reasonable doubt every single element of the DUI. Now, in the administrative case, the burden is far different than the criminal case. It's a more likely than not standard. Actually, the burden is on you to prove the case, as opposed to on the criminal case, it's on the state. Now, in this video, now that you understand the context in which we're discussing, I'm going to talk about ways that you can possibly win your administrative case. Now, the law in Kansas is very pro losing your driver's license, and when you're talking about any type of administrative case, especially if you refuse a breath test. If you refuse a breath test, you always have a better criminal case, but you're going to have a higher burden on your administrative case. And the burden of proof on a refusal is that you have to prove that it's more likely than not that the officer didn't have reasonable grounds to ask you to take the test. As far as reasonable grounds, that is the lowest recognized standard of proof in the legal system. So how do you win? How do you, faced with these really hard burdens in which you have to prove things and the state doesn't have to prove anything, how do you win these administrative hearings? The number one way people win these hearings is just taking a really good look at the paperwork. And the administrative process is hyper-technical as far as a bunch of what seem like they're not important aspects to whether a person was drunk driving or not, but are important to whether a person keeps their driver's license based on an administrative hearing. I'll give you a couple examples. So on the DC-27, that is the Bible of whether you are going to keep your driver's license or not. Errors on the DC-27, whether they're what seem like minor errors, can be the linchpin that gets your driver's license back. Other things that seem like major errors won't have any effect on your driver's license. Some examples would be if an officer failed to certify questions 1 through 4. Sometimes those are automatic kickbacks, depending on what the officer certified. You can look at the service. One of the last statements that the officer certifies at how they perform service on you. If the officer doesn't give you personal service after it's a refusal, well, then you might have an issue to get an automatic kickback. If the officer doesn't sign the DC-27, they may print out all their instructions on it, they may print their name, they may print the office in which they represent, but if they don't actually physically sign the DC-27, that might be an automatic kickback. When I say automatic kickback, I mean you might not even have to begin the administrative process to keep your driver's license. The state might just send you back your driver's license. This area of the law is very technical, and you want to sit down with a lawyer who does a lot of DUI work, bring all your paperwork at the initial consult, talk with them over your DC-27, talk about the facts of your case, and apply those facts to the law. If you have any questions in this area, feel free to contact my office for a free consultation.